Hey, we've got some good news for federal employees. The Merit Systems Protection Board just got its quorum back. So that means final board level decisions on your appeals can move again. So quick refresher, what is the MSPB in real terms, or the Merit Systems Protection Board? Well, it's the neutral body that reviews major personnel actions. Think removals, long suspensions, demotions, furloughs of 30 days or less, whistleblower and veterans' rights cases, and mixed cases that include discrimination claims. So day to day, your case usually starts with an administrative judge, also called an AJ, who runs the hearing and issues an initial decision. If either side challenges that ruling, the three-member board in DC does the final review. So why today's news matters? Well, yesterday on October 7th, the Senate confirmed James Woodruff, restoring the board to at least 2 members, the minimum needed for a quorum. Without a quorum, the AJs could still hold hearings and issue initial decisions, but the board couldn't issue precedential nationwide guidance. It couldn't decide petitions for review. That's the appeal of an AJ decision, and it couldn't act on certain time-sensitive stay requests. With a quorum, those gears turn again. Your petition for review can get a real final answer, and the board can publish decisions that tell every agency exactly how to follow the law. Context for why this is a relief? Well, between 2017 and 2022, the board lacked a quorum and a backlog exploded, right? About 3,800 cases piled up before it was finally cleared in fall of 2024. Now, this year's appeals spiked again. By May 2025, the MSPB had already received roughly 11,000 appeals, a lot of those RIF appeals, about double a typical full year. AJs have been carrying the load, but when the board can't rule at the top, uncertainty spreads across agencies. A quorum helps prevent that pileup from returning. So let me translate the process in plain steps so you can spot where you are. You generally have 30 days to file an appeal with the MSPB after an adverse action becomes effective, or 30 days after receiving that decision. Missing that window can end your case before it starts. Now, what usually happens is the AJ issues an initial decision, so if you win, the default rule is interim relief. Think temporary reinstatement while the case is on appeal, unless the judge finds a specific reason not to order it. Back pay and attorney's fees usually wait until the decision. Either side can file a petition for review to the 3-member board. The deadline is 35 days from the initial decision or 30 days from when you actually receive it, if that was later. With a quorum, these petitions can be decided again, finality returns. So if you ultimately win, remedies can include reinstatement, back pay with interest, corrected records, in some cases attorney's fees. It just depends on the case. 2 more things to watch, I think, is the shutdown caveat. The MSPB has paused most operations during the funding lapse. When the government reopens, the quorum is waiting, so petition decisions and precedents can restart instead of stacking up. Also, we wanted to let you know about a new development. It hasn't passed yet, but there's conversations about it. It's called the new Fast Justice Act. Senators introduced a bill that would let employees take their MSPB appeal to federal court if the board hasn't acted within 120 days. Essentially a pressure valve against delays. A similar 120-day off-ramp already exists in certain discrimination mixed cases. The bill would broaden that kind of relief. Even with the quorum back, this proposal is worth tracking because it could change your options if delays return. So why this is good news? Well, the bottom line is a functional board means clearer nationwide rules, faster final outcomes, and less risk that strong AJ wins would set in limbo. It also means agencies get consistent guidance on penalties and due process, so you're less likely to see wildly different rules for the same facts in different regions. If you're in the MSPB pipeline now, note your filing deadlines. You should still follow those, keep every notice, and if you have an initial decision pending, count that 35-day petition for review deadline. If you've already filed a petition for review, the quorum is the green light your case has been waiting on, and once the shutdown ends, the quorum can start working on cases. We know how much is writing on these decisions for your career, your family, and the record. We'll keep translating each step in plain language with the legal muscle behind it. Thank you, everybody, for your support. Hope you found this helpful. Take care and have a good day.